good afternoon to all of you. It's just a few minutes after noon, so welcome to this second panel of the 7th OECD Competition Open Day. My name is Antonio Capobianco. I'm here at the OECD with the Competition Division, and I have the pleasure and, of course, the honor to moderate this panel on the standard of proof in competition law. Now, before I introduce our panelists, let me put down a few dots for you, and I'm sure that the panelists will then help us connect those dots in a moment. Now, I always start my presentation with a quote, and I found one from 1605 when William Shakespeare wrote in King's Lear, "Striving to better, oft we mar what's well," and I apologize if Dame Judi Dench is following, because my Shakespearean acting is terrible. But what you meant to say is that we must be careful not to desire the perfection, because that could be the enemy of good. And about 4 centuries later, 400 years later, another William, Bill Kovacic, very well known to all of you, former chairman of the US Federal Trade Commission, made a similar warning insisting on excessively high standards of proof or procedural obstacle may harm the authority's ability to promote effective competition through enforcement. Now, in our discussion here, we have seen that in many jurisdictions there is an increased demand on competition authorities to engage in a more economic and more effects-based approach to establish competition law violation. And this has raised policy questions of whether the standard of proof and the related evidentiary standard have been set at a level which is high or too high, making it excessively difficult for competition authorities to prove their cases and therefore potentially affecting the effectiveness of enforcement itself. Now, is this just a perception? Is there something beyond that? Is it a myth or is it a reality? Is there something that should be done to address this issue? What are the risks and benefits of playing with legal standards, of moving the burden of proof from one party to the other? This is some of the questions that we'll be exploring today. And we chose this topic for this open day because last year the Competition Committee and Working Party 3 had 2 discussions on some of these questions. The session on the standard of burden of proof in competition law cases explored the current policy landscape of evidentiary elements for decision makers, while the session in Working Party 3 in WP3 on the use of structural presumption in antitrust explore the use of structural presumption and how competition authority can use them to address complex analysis in cases, and at the same time maintaining the required degree of due process and legal certainty. So we wanted to bring that discussion to the open day here today, but we encourage you to scan the QR code and access the documents. Maybe there are copies also in the back of the room if you are interested in digging a little bit deeper. Now, a couple of definitions, because when we were looking at this, we saw terminology used in different ways and sometimes in conflicting ways. So as a definition, the standard of proof indicates the degree to which a party must prove its case. And it sets the threshold of evidence required to consider an element of a case proven for the purpose of the decision to be taken. These standards, of course, varies depending on the legal consequences of the decision, the civil, administrative, or criminal. So the more severe the consequences, the higher the level of persuasion which is required to rebut the presumption of innocence. So criminal standards tends to be the highest standard. The burden of proof, on the other hand, indicates who must adduce evidence in support of an allegation and determines who will suffer the consequences for not proving a fact to the requisite standard. It is general legal principle in many jurisdictions, in OECD jurisdiction, in many other jurisdictions, that parties to a case must prove their claims or their defenses, and deviations from or exception from these general principles must be sort of narrow and must be strongly grounded because they ultimately reverse the burden of proof. Now, the evidentiary standard refers to the level and the quality of evidence required to establish a fact as a violation. And this is crucial to make sure that competition authorities can effectively enforce the law while maintaining, of course, due process and fairness in antitrust proceedings. So let me explain a little bit why this topic became, which is not a new topic, it's a classic topic, a standard of proof, burden of proof, not only in competition cases, but generally in legal systems. So why the competition committee and our delegates were interested in discussing this issue. And I think you had echoes of that in the previous panel. On the one hand, we have been, the OECD, looking at complex market, dynamic markets, technology markets for a long time, and there was a perception that in dynamic and complex markets, these require higher efforts by decision makers to accurately prove either past conduct or predict future behavior. There was some discussion about merger control early on. And in these markets, they are known to be changing very rapidly. There are shifts in competition and market structures, and they make the use of traditional, more static analysis more challenging to apply. But the shift towards a more dynamic approach strengthens definitely the competition cases, but may have also increased the difficulty of meeting the applicable standard of proof. On the other hand, the standard of judicial review has also determines if competition authorities have met the standard of proof, and the intensity of judicial review has increased over time, and courts may have an impact on how difficult the task of competition authority is in proving cases in the first instance. Now, a quick word, at least from my perspective, in my view, about how these three standards play, what's the interplay between these three standards. Now, the standard of proof, whether it's set in the legislative framework or through established case law by courts, tends to be a factor in general which is rather stable. There have been proposals over time to move the standard of proof, for example, to move from balancing of probabilities to balancing of harm, but we have not really seen movement or significant movement in the standard of proof. While on the burden of proof, so who has to prove what in a case, I think we've seen a lot of movement over time and across jurisdictions, and this is has been subject to changes over the years, depending on the different way that each country, each jurisdiction gives to formal as opposed to effects-based enforcement, to the size of by object or per se provisions, as well as safe harbor, so what is presumptively anti-competitive or presumptively pro-competitive. And all these charges, of course, affect the burden of proof of the plaintiff or defendants that must discharge to win their cases. Finally, between the standard and the burden of proof sits the evidentiary standard, so how much evidence an authority or a plaintiff needs to bring to win its day in court. And there we have witnessed a rather, I would say, linear development towards constantly increasing demands on the parties to competition cases in terms of proof that they need to bring forward to convince a judge or a decision maker of their arguments. Now, the alchemy between these different standards is a complex one, and it's, of course, soaked with policy consideration. This is why the OECD has been sort of looking at this, and it's easy to imagine how by modifying one standard, one can make public enforcement easier or more complex, can expand or reduce due process rights, and emphasize or de-emphasize the general presumption of innocence, with repercussion on how society perceives the enforcement system. Now, with this in mind, there are a lot of questions that we could look at, but some of the questions that we will explore with the panelists today is whether we should alleviate the burden of proof on competition authorities, should we expand per se or by object restriction boxes, should we introduce new presumptions, there's been a lot of discussion about that here at OECD, should we have different standards for different markets, the more complex one as opposed to easier markets to be analyzed? Does the standards need to change, whether we're looking at merger control or behavioral cases? What are the risks and benefits of playing with these, with the alchemy, with these different standards? And how can we assure that competition authority can handle this trade-off between sort of due process and enforcement flexibility? Now, to address some of these questions, we have three wonderful panelists, which I will introduce in no particular order. Marc van der Woude. Marc is the president of the General Court of the European Union. Next to Marc is Professor Kang. Soo-jin is a professor of criminal and competition law in Korea at the Korea University Law School. And next to me, we have Daniel Haar, is from the US Department of Justice, chief of the Appelate Section. So in this sort of Shakespearean play, I think the roles are pretty clear. We have a prosecutor. He has to convince judges of cases that the prosecutors wants to bring. We have a judge from a completely different jurisdiction, but Marc is the judge who reviews on appeal decisions of the European Commission on competition, and in between them we have the academic who has been thinking about the system from more of a policy and general perspective. But there is a fourth voice that we'd like to hear today, and it's you. There are a lot of familiar faces in the room, a lot of people from businesses, from private practice, so we really like to bring you in as much as possible this conversation, and we have thought about doing this in two ways. 3 times through the discussion you will see a poll question appearing with a QR code, so be fast, be ready to scan the QR code, and there will be questions for you. We'll see then if you agree or disagree with what our panelists will say in the discussion. We also have time at the end for some questions from the room or for those who are online, so be ready to raise your hand when we'll ask you to interact with our panelists. Now, to go back to Shakespeare, I think in Hamlet, he says, the play is the thing, so let's raise the curtain and let's start our conversation. And I think the first question is the question for the panel, for this session: myth or reality? Are we overstating the problem of the standard of proof and the burden of proof, or is there something that needs to be revisited? And I wanted to start with Marc, but before we do that, I wanted to the first poll question to go up on screen, because we would like to ask you, what do you think about the evidentiary standard for proving anti-competitive practices? Has it become overly demanding for competition authorities or for plaintiffs? The answer are, hopefully we'll give a polarized views. We'll see the different views in the room. Is it yes, it is too high, the standard is about right, or is it too low? Or maybe it depends on markets and behavior. But Marc, maybe you can set the scene here, and competition cases in Europe, and I'm sure you can speak for European experience very much. I mean, courts often require a high level of evidentiary standards before finding or confirming a decision by a competition authority. Has the standard gone too up? Is it too high? Is it creating a problem? What's your perception?
Thank you. It's an interesting question, because if the same question had been put 25 years ago or 30 years ago, the question would have been, is the standard too low? It's never right, I presume. It's a pendulum in history. But it's a fact, of course, that if you have an effects-based or an effects-based economic approach, that is certainly more burdensome than simply hard and fast rules. I think we can agree on that. But it's difficult to answer the question, is it too high, too low, in the abstract. I think it's a process which involves many actors, and courts are only one of those actors. First, you have the legislator. In Europe, we had Regulation 1/2003, which paved the way to a more economic approach, which was taken up by the Commission in a series of notices and guidance paper that also influenced the courts. Then, as regards the courts, which had already a more economic approach, I would say, than the Commission in the 90s, for various reasons, essentially procedural reasons. But it all culminated, for example, before the General Court in the Air Tours and Tetra Laval cases of 2002, and ever since it became more economic. And I think the key judgment is of the Court of Justice in Intel in 2017, where it marks a clear end to a purely form-based approach. However, I would say, in that system, the tide is turning. If you see at the legislative front, you get rules like the DMA, which rely on hard and fast rules. If you take the Commission, which has to enforce the DMA, it also moves things from the effects box to the object box. And sometimes I ask myself, how big is this box? So it's the second trend. And then even the courts. If you take the latest Intel judgment of the 24th of October of the Court of Justice at the end, it marks clearly that, okay, this AEC test is interesting and we validate what the General Court said, but it's only one way to prove your case. A similar thing is said, for example, in Unilever Italia. Also a warning, an effect-based economic approach is one way to prove it, but there are many other ways. So I think the tide is turning in a certain respect. But just to say that courts are only one actor, but in the play, I don't know whether it's Shakespearean or not, but I will play the role of the court on a purely personal title. And then also focusing on the court in which I sit, the General Court. And perhaps for the audience which is not European, we have a peculiar system in that sense. We don't rely on prosecution, or it's not a criminal enforcement case, it's not a civil case. We are an administrative review court that, as Antonio already mentioned, controls the legality of Commission action. So if the Commission takes a decision, the companies which don't agree with it can appeal before our court. That's important when it comes to the burden of proof and what you have to prove. For example, if Daniel brings a case, in a criminal case, he has to convince the judge that there is an infringement of an antitrust law. And it's the judge that takes the decision. In our system, it's the Commission that takes the decision, and the applicant has to show that the administration made an error in finding an infringement. You may think it's a nuance, but it is an important nuance, because we control the legality. We do not establish the existence of an infringement or not. And when we exercise that task of legality review, we rely on the means, or say the pleas and arguments put forward by the parties. So if you have the wrong arguments, or if your pleas are not convincing, and which do not succeed in showing that there has been an error in the assessment of the authority, the case will be rejected, even if the judges think themselves that there have been an infringement. So if you don't show the illegality of the decision, regardless of, say, what the content of the decision is, your case will be rejected. And in that system, the question is, how much leeway do we grant to the authority? And that's the question of the intensity of judicial review. And that's the second point I would like to make. There again, I think Antonio already alluded to that. There are various decisions, and the intensity of review varies according to the type of decision in front of you. For example, if the decision is criminal or quasi-criminal in nature, the standards will be higher than if it's simply an administrative decision which rejects a complaint, for example. If you get into the criminal field, the standard is that if the applicant succeeds in showing that there is doubt or reasonable doubt as to the existence of an infringement, the decision will be annulled. That's different when it comes to authorization decisions. For example, when you look into the future, when it comes to merger review, and the Court of Justice reminded that in the CK Telecom case, I'd say it's a neutral test whether the merger has to be approved or have to be prohibited. It's the same test. And it's an ex-ante assessment, which is, of course, much more difficult to make than having an ex-post control on the existence of an infringement in the past. So that's an important difference. But to that, I would like to add two other types of decisions. The criminal ones are known, the merger ones are known. But we have a new kind of decision which relies on presumptions. That's the DMA type of decision. We had a judgment in July last year, the first judgment under the DMA regulation, where the General Court upheld the Commission decision, and the Commission decision said that the applicant, in this case TikTok, or the parent company of TikTok, had not succeeded to reverse the presumption that it was a gatekeeper which met, to say, the quantitative thresholds of Article 3 of the DMA. And the interesting thing there is that under the DMA, the regulation itself seems to specify the type of judicial control which the General Court has to exercise, and the General Court reminded that in its judgment. It said, did the applicant submit sufficient substantiated arguments manifestly calling into question the presumptions? That's a very different test from the criminal one to which I just referred. By Dance, the case was rejected. And finally, and that's more on a personal note, there is a fourth category of cases which, in my view, cause concern, and which are perhaps not on the radar screen of the discussions. It's inspection decisions. I see a trend that more and more companies call into question the inspection and fact-finding decisions of authorities. So when in Europe it's a request for information or a dawn raid. And of course these fact-finding missions are very intrusive, and they call for full judicial control. They raise all sorts of questions as to data protection, privacy, freedom of expression, all sorts of things when it comes to journalism, for example. That's an interesting trend. The question is, where do you strike the right balance by making sure that the authority can exercise its fact-finding powers in a context in which leniency applications run dry? And how do you ensure at the same time a good protection of fundamental rights? So 4 types of decisions: criminal, authorizations, presumptions like the DMA, and inspection decisions. Now, my last observation is, what is the type of evidence you can use in those type or in your applications against those 4 types of decisions? Basically, under the European system, the choice is yours. Any argument is welcome as long as it is convincing. So the argument is not what type of evidence you're going to put forward, but how convincing is that argument. There is no hierarchy in the types of evidence you would put forward. However, of course, there are general rules like contemporaneous evidence is more convincing than evidence produced ex post. Or, for example, when it's something in writing, it's more convincing than an oral statement. Direct evidence is, of course, more convincing than indirect evidence, but those are general rules which apply across the board. And in that cocktail of arguments you can put forward, you can also use economic arguments. We see a trend, that's exactly your point, of increased use of economic evidence. It has gained much of importance, especially in the Intel cases. But as I said, it's just one means to prove the existence of an infringement or to show that there has been an abuse more in particular. But it's the authority that chooses the path. If it decides to go on the economic route, of course, it can expect economic arguments. If it goes down another path, it may be another category of arguments that will be put forward. The Court of Justice specified, however, that when a company raises an economic defense, the authority and the court must engage in that argument. But the theory of harm is the choice of the authority itself. So to conclude, is it too high or too low? Quite frankly, I don't know. History will tell. It's a pendulum, and probably we will find the right balance somewhere in the middle collectively as a community. One thing of concern, though, are these inspection decisions. We should make sure that the system stays alive, and for that, the authorities need information and need fact-finding powers. I thank you for your attention.
Thank you, Marc, because clearly this question of whether the evidentiary standard is too high or too low is not a yes or no kind of question. It's much more nuanced, and you have walked us through some of the nuances of the differences in cases and type of evidence that one can use. But maybe you mentioned, of course, the differences between the European administrative systems and the US American system, where Daniel and his colleagues have to convince a judge about the solidity of their cases, so they spend all of their time, most of their time, building up cases and collecting evidence. Have you perceived a difference over time in terms of how easy or more difficult your job has become in that respect?
Thank you, Antonio. Thank you, Misha. Thank you, others at the OECD, for having me here today. I just want to say at the outset, I'm here from the US Department of Justice Antitrust Division. The views I'm expressing are my own and do not necessarily reflect those of the US Department of Justice. I'm an appellate lawyer, and usually we are taught to answer questions framed in a yes-no structure. You answer them with a yes or a no, but like others on the panel, I think I'm going to avoid answering the myth or reality question with a yes or a no. I can give you examples from our legal history, and I think by giving those examples, setting out the framework, it'll help answer, at least shed light on the ultimate question. In particular, it's just not my role as a government enforcer to speak to whether reforms are necessary. We enforce at Department of Justice, we enforce the laws as they're written. But there are interesting examples, and in some ways they reflect, some of the context that Marc was talking about. When Congress passed the Sherman Act in 1890, when it passed the Clayton Act in 1914, when it revised significantly the Clayton Act in 1950, this is really before the modern economic tools that we've come to use substantially in our cases were developed and refined. The text of those acts don't refer to economic proof. The Clayton Act, Section 7 of the Clayton Act, which is the primary tool we use to challenge anti-competitive mergers, simply speaks to a merger being unlawful where the effect may be substantially to lessen competition in any line of commerce in any section of the country. So you can use economic tools to prove liability under the Clayton Act, but there's substantial case law, a lot of it going back to the 1960s, but also from later, that establishes that that's not the only path. So I think we're similar to Europe in that respect. Market definition questions. Obviously, you can prove through a hypothetical monopolist test, but you can also prove using companies' documents, witness testimony, what the sort of zone of competition that is relevant in a given case. Even competitive effects. Obviously, you can introduce complex or more simple economic models, regression analyses, simulations, and others to show the likely effects of a merger or other conduct. But it's not the only way of proving that. And often business documents shed just as much light. What was the intent behind certain actions? Our system is one in which intent isn't the primary question. It's usually more effects focused, and that's true under the Clayton Act. But the case law also makes clear that the intentions behind businesses' actions sheds important light on the ultimate effects. And so documents that show that an intent behind a merger was to eliminate a competitor is very probative evidence of what the likely effect of that competitor. People on the ground in the business world are some of the most informed people of what the effects of various actions they take will have. So there are a number of ways in which we can prove our cases. And as Marc and Antonio said, in the United States, we enforcers, we do rely on the courts. We make out our case, we file a complaint which says what we intend to prove, we go into court, we have witnesses introduce evidence, but it's ultimately up to the courts to decide whether we made out our case or not. Then it may go up on appeal, and that's when I actually get involved. But it means that we're not we are forwarding our view of the law and the facts in the first instance, but what ultimately wins the day is what the court says, or if it's a criminal case, it's what the jury says. I'm going to focus my remarks mostly on the merger context. There's so much to say about competition law that it probably would go on too much if I didn't narrow, and I think there are a lot of interesting things to say in the merger context. I think one thing that may shed light on this question is just sort of what's the arc of what the cases have looked like. I think, since especially the 70s and 80s, we've had much more sophisticated understanding of the economics that go into proving what the contours of a market might look like, what the effects of particular, mergers between substantial or weaker competitors might have. But in some cases, the sophistication of our economics has backfired. In developing these great tools, we've also just added more and more layers of complication. And sometimes it goes beyond the level of the fact finder, the judge, or the jury, to truly understand the significance of the competing models between plaintiff's expert and defendant's expert. And then ultimately in those situations, and you've seen a number of cases where judges have said largely, the economics kind of cancels out and maybe the documents win the day. In some other cases, you almost see that the economics creates an expectation that the level of the standard of proof has increased. We've developed these complicated models, and maybe to some judges, they come to expect them simply because we've gotten in the habit as plaintiffs of introducing such evidence, or defendants' counsel has been. So now I'll refer to a few of the Shakespearean actors. There's plaintiff's counsel, there's defense counsel. We're all responding to what's going on in the academy, the different schools of economics out there who have ideas about what we should be showing in a particular case. But plaintiffs can create an expectation of what kind of proof will be made. Obviously, defense counsel will make arguments that you need such proof. And, sometimes that becomes an expectation in judges' minds. I think there are a couple of cases out there. Just to name a couple, I think the United States' case against the vertical merger, AT&T, Time Warner Cable, it may be an example where AT&T, Time Warner, maybe an example where the judge simply expected a higher level of economic proof, to a greater decimal point than was simply possible in that case. Or you have another example, it's the state's case a couple years later against two cellular service providers, T-Mobile and Sprint, where again, read the decision, there was a certain level of economic precision that seemed to be expected in the case. This isn't to say this is what the standard as written by Congress requires. So when we're thinking about, is the standard too high, Congress set the standard largely, there have been a few minor changes, but Congress set the standard largely in 1950. There has been variation over time in how courts have applied that standard. We have been winning cases. The U.S. Department of Justice has been winning cases. There are a number of Clayton Act victories. We had one recently against two book publishers. Penguin and Simon & Schuster proposed a merger that was blocked by the courts. We had another victory against two airlines who proposed to merge. And we've had victories under the Sherman Act as well. One, a merger-like arrangement between American Airlines and JetBlue in the Northeast United States. That was the Sherman Act Section 1. And we had not a merger case, but we won at the liability stage against Google for its conduct in the search market. So we are able to win cases under the existing standards. And we all are also quite actively involved as an amicus in cases brought by private parties simply to advocate for what we believe is the right standard for courts to apply. And I think that can have a beneficial impact going forward.
Thank you, Daniel. And maybe we can come back to this also. As some reforms ongoing of these proposals to change the law in the US. But maybe I can bring in Soo-jin in this conversation. Clearly, one size fits all is not the answer to the question of the evidentiary standards. And there are clearly specific challenges when you're looking at behavioral cases or cartels or abuse of dominance, proving facts that have taken place in the past, as opposed to maybe mergers, like Daniel was saying, that looking at how a particular transaction will impact the market. How do you see these sort of the complexity and the differences between these different type of cases?
Thank you. First of all, I'm very happy to be here and share my ideas with all over the world. And the question is very difficult, as Marc said, and in a narrow sense, as the standard of proof refers to the degree of conviction of a judge must reach in order to find a violation. The principle itself cannot vary by types of cases, I think. The standard of proof in competition law cases also should be aligned with civil or administrative litigation. And in Korea, unless special circumstances exist, the standard of proof is considered satisfied if there is a high degree of likelihood based on experience that a certain fact occurred. But I think I understand that. However, abstract standard principle cannot guarantee the predictability, especially competition law cases, unlike civil or criminal ones, require proving not only simple historical fact, but also the behavior that has anti-competitive characteristics. And these anti-competitiveness encompass not only past or present impact, but also the specific risk that may arise in the near future. And proof of such normative evaluation involves demonstrating things that are not visible. So hence, indirect evidence or circumstantial evidence are more important than the direct ones. Generally, when relying on circumstantial evidence, determining whether the standard of proof has been met primarily depends on the discretion of the judge, as Marc said. But excessive dependence on the judge's discretion makes it very difficult to ensure predictability. We are wondering whether yes or no, but judges cannot speak about that, so that's the question. So, therefore, especially in cases of abuse of dominance or merger cases, where proof of anti-competitiveness are very crucial, it is necessary to specify the types and scope of circumstantial evidence required to satisfy the standard of proof. So, in my opinion, as a short conclusion, whether in the form of guidelines issued by administrative authority or judicial precedents by the court, the evidentiary standards should be further clarified and concretized through mutual feedback between judiciary and competition authority. And by giving at least de facto binding forces to those kind of guidelines, it could ensure kind of predictability for both competition authority and businesses. Thanks.
Thank you. Thank you to all of you. And let's see what you guys think in the room. And if we can put up the results from the first poll question, it's quite interesting because 23% of you think that the evidentiary standard is too high. I wonder whether that's probably the enforcers in the room who have a lot of headaches proving cases. There's a 20%, almost 20% that thinks it's too low. So maybe these are the practitioners in the room who would like to be more demanding on competition authorities when bringing their case forward. 17% thinks that the evidentiary standard is about right, so maybe we're having it's just a myth, all this discussion. There's nothing to discuss. It's good as things are. But there is 40% of you in the room who really think it depends, and I think it reflects a little bit the comments that we heard so far. So maybe we can go into try and explore a little bit more that nuances about different cases, different behaviors, and maybe I can maybe we can put up the next poll question so you can start thinking about whether the standard of proof should be adjusted depending on the complexity of the conduct. So look a little bit deeper into this diversity of cases. And maybe I can come back to you, Daniel. You started exploring consideration in the merger context, and mergers can be challenged by the U.S. agencies, both under the Sherman Act and the Clayton Act. There are different standards, different challenges. How do you see this question about different type of cases, maybe going beyond mergers if you want to expand a little bit in different standards?
Thank you, Antonio. I'm going to start with talking about the Sherman Act. I think for folks who are quite knowledgeable about merger enforcement in the United States, people often simply focus on the Clayton Act, which is a later statute, because it's much more targeted at mergers. But the Sherman Act actually is the first act, it's both the first antitrust act passed in the United States, dates back to 1890, and it is also the first act that applied to mergers, and it still does apply to mergers in some contexts. And then perhaps more importantly, understanding the Sherman Act standard helps clarify what the Clayton Act standard is, since the Clayton Act was passed in the backdrop of the existing Sherman Act. I'm not going to talk about per se violations, since I'm going to focus on mergers. Generally, per se violations are things like price fixing, bid rigging, and market allocation, which inherently eliminate competition and have no redeeming benefit. Mergers, because they bring together companies' productive assets, into a collaborative framework, have the potential for pro-competitive benefit, and so are, when challenged under the Sherman Act, analyzed under the rule of reason. So I'll focus on the rule of reason under the Sherman Act. That generally has two elements. One, you establish what the relevant market is. That's the zone of competition. It has a product and a geographic dimension. I think this is common to almost all competition regimes across the world. And then the second is you show the effect of the practice, here a merger, and under the Sherman Act, you show either actual or probable anti-competitive effects. There's some cases that apply these standards specifically in the merger context. One of the biggest ones is a case called United States versus First National Bank and Trust Company of Lexington. This is from 1964. It was a horizontal merger between two banks, and the Supreme Court held that where merging companies are major competitive factors in a relevant market, the elimination of significant competition between them constitutes a violation of Section 1 of the Sherman Act. In that case, the two companies merging had a combined share of over 50% of the relevant commercial banking market, and the court applying that standard held that their merger was unlawful. Recently, and this is not quite a merger example, but it is an arrangement between two companies that shared a lot of characteristics of a merger, so I think it's relevant in the context. But American Airlines and JetBlue not only proposed, but entered into a relationship called the Northeast Alliance, where they effectively acted as a single airline in the northeastern United States. This was routes in and out of Boston and New York City. And the district court, this is the trial court, held that it violated Section 1 of the Sherman Act. These were two main big competitors in the Northeast region, in the relevant markets, which were defined at the route level. Elimination of one of those competitors by what was essentially a market allocation arrangement in which one or the other company would operate on each of the routes for the most part. There were other routes in which they tried to at least focus on one would compete at one time, one would compete at another. But the district court found that was unlawful, and the Court of Appeals upheld that finding by the district court. And the Court of Appeals, interestingly, said that when one of the airlines pulled out of a market, that was an output reduction, and that satisfied the rule of reason burden. So that's the general picture of the Sherman Act. Again, the Clayton Act is much more used for going after mergers. In 1914, the Clayton Act was passed. Initially, it applied only to stock acquisitions. In 1950, it was revised to apply to mergers and asset acquisitions. So that's the form in which we generally understand the Clayton Act today. In Brown Shoe, this was the first case in 1962 in which a Clayton Act Section 7 case under the revised statute went up to the Supreme Court. The court made clear that the Clayton Act is an incipiency statute. Now that's important because the intention of Congress in passing the Clayton Act was to attach liability to an anti-competitive transaction prior to the type of effects that would be required to show a violation under the Sherman Act. So under Brown Shoe, which is still on the books today and reflects the evidence of what Congress intended when passing the 1950 revision, the standard of proof is lower in a Clayton Act case than in a Sherman Act case. So wherever you set the standard, or wherever a court understands the standard to be in a Sherman Act case, it should be lower in a Clayton Act case. Now, generally similar tools are used in both situations to understand the likely effects. We're talking again about economics, business documents, witness testimony, but just the sort of level of proof that's required should be less given that sort of foundational understanding of what the Clayton Act is. That said, there are cases, especially in the 80s and 90s, that started to talk about the standards having converged under the two acts. Again, I think this is reflective of the fact that plaintiffs were coming in with economics evidence and saying this is likely going to harm competition. The way plaintiffs presented cases just sounded the same in the Clayton Act and Sherman Act context, and courts reflected that sometimes in their decisions. The seminal case discussing that potential convergence is Rockford Memorial. It's a Judge Posner decision. But I think if you truly understand the landscape and you go back to Brown Shoe, it's quite clear that the Clayton Act is an incipiency standard. The bar is set lower under the Clayton Act, higher under the Sherman Act. So convergence may be in the sense that there are similar tools used, but not to the extent that the standard of proof is the same, because Congress clearly intended a lower bar for the Clayton Act.
Thank you, Daniel. And maybe a question for you, Soo-jin, because I understand in Korea there have been some legislative initiatives to change to address some of these challenges with the standard burden of proof, especially in cartel cases, if I understand correctly. More on relevant the challenges that the KFTC had with market definition and dominance, market power.
Yeah.
So maybe that's where they focused the initiative.
Yes, newly emerging markets. Yes. Yes, I will introduce some Korean revision about the online platform markets. So the emergence of online platform markets, such as searching engine or internet portals, complicates market definition due to the characteristics such as multi-sidedness and the cross-network effects, economies of scale, and etc. So to address these issues, Korean Fair Trade Commission introduced new guidelines for reviewing abuse of dominance by online platform operators and supplementing various principles for market definition and market share calculation. For market definition, it allows for either distinguishing or encompassing different user groups, and also it includes nominally free service market, and it reflects dynamic characteristics like technological advancements and new product developments. And for market share calculation, where revenue-based calculations are impractical, alternative methodologies such as volume, user numbers, or usage frequencies could be utilized. And also we have some legislative efforts ongoing, and I will introduce shortly about that. And the current legislative efforts developed are discussed in two different directions. The first direction is ex ante designation approach. It's quite similar to DMA approach, pre-designating dominant platforms for regulatory purposes. And the second, another direction is ex post presumption approach. It identifies and regulates market dominance based on presumptive rules after an alleged violation occurred. And last September, Korean Fair Trade Commission announced to adopt the ex post presumptive rule-based approach by amending the Fair Trade Act, and which includes specific presumption criteria, new regulating sectors, and new abuse types for online platform operators. And KFTC has sent this proposed bill to the National Assembly, but there is still ongoing debate regarding the content of the proposed bills and especially the direction itself. Thanks.
I'm conscious of time, but I wanted to ask a very quick question to you, Marc, as well, because there have been some proposals in Europe in 2019 in the report on competition policy for digital era that maybe the burden and standard of proof should be recalibrated, especially for this complex market, the digital markets that have become so important for authorities around the world. Do you think those proposals are in line with the case law of European courts and of your courts, of course?
First, I think, to whom do these studies address themselves? Are they addressed to the regulators or to the courts? Of course, the regulators set the scene by taking the decisions under our European model. For courts, it's more complex. It's only when the treaties, the charter, or the secondary legislation clearly specifies what the legal test should be. For example, I mentioned this example already of the DMA. That's a typical example in which the legislator itself made the choice as regards the intensity of review. Apart from that, the courts are, I would say, autonomous in deciding how to deal with it, of course, with the Court of Justice having the final say. Now, the question for me, when it comes to complex cases and the need to come to a timely answer to be relevant as a court, depends essentially on the way you handle the case. And there are some changes. So for example, at the Court of Justice, when there's a case on appeal, there's a tendency now that the Court of Justice takes up the case itself, doesn't send it back, that we don't end up, for example, in a saga like the Intel saga, which is not yet over, and the facts go back to the 90s, the case is not yet over. So that's a bad example. So we are aware of that, so the Court of Justice will take up, if the case is fit for that, the case itself and will deal with it rather than sending it back to the General Court. That's one change. At our court, we have changed the way we approach these important big cases by having a more project management approach rather than the classic approach of which we use it in most of the cases. So we ensure that there's sufficient staffing and that the case can go forward quite rapidly. So we also make sure that the judge focuses on that particular issue. And finally, I would say, what the Commission should draw from, what are the consequences the Commission should draw from these developments and from our case law? It's a bit what Soo-jin said. It's an interaction. When you see, for example, the notices published by the Commission, they often rely upon the case law of the court. They make the notice, which again is then sent to the court and is used as a benchmark in the judicial assessment. So yes, these studies have an impact because they influence the regulator and they will influence, say, the whole chain, but the courts are independent. It's only when the legislator has made the choice as how it should be that the courts can do something.
Thank you. And let's see now the results of the second poll question, which is quite interesting. If you can put it up screen. Yes, I think it seems that very few of you think that we should make life of authorities easier, so that the standard should be lower. So most of you think that it's about right, so it should remain the same. But it's interesting, like a number of you think that maybe new approaches by competition authorities needed. It depends really on cases and industry, and maybe that offers an opportunity to move to the last part of our conversation, because a number of you have mentioned presumptions, and there's been a lively debate on the use of presumptions, including structural presumptions, expanding the scope of these presumptions, the application of these presumptions, and this is something that maybe we can put up the last poll just to see what you think about the use of presumptions in antitrust cases, and maybe Soo-jin can help us navigate this question that has kept us busy also here at OECD, because I think new presumptions are being sort of adopted or included in the Korean system, especially this time, I'm right, in cartel cases.
Yes, I would introduce some cartel presumption provisions in Korea. In cartel cases, as you know, it is necessary to prove the existence of the agreement between business operators. And such agreements include not only explicit one, but also implicit agreements, tacit consent, and just passive acquiescence. The critical issue lies in the how to prove implicit agreements. With the increasing tendency of businesses to leave no explicit traces, it is more and more complicating. And yes, when proving the key facts through indirect implicit evidences, the standard of proof becomes particularly contentious. It is especially challenging to distinguish and prove whether conscious parallel behavior in an oligopolistic market stems from an agreement or pure interdependence. The KFTC, Korea Fair Trade Commission, has endeavored to infer agreements by presenting circumstantial evidence such as market concentration, market characteristics, and economic logic behind similar conduct and information exchanges. However, Korean courts have consistently demanded strict evidence of meeting of minds and have ruled that mere circumstantial evidence of concerted practice does not suffice. And for example, in the price-fixing case among instant noodle manufacturers in Korea, the Supreme Court ruled that statements regarding specific agreement details were either hearsay or not directly experienced, making it difficult to ascertain or trust specific content of the agreement, and merely exchanging information was not sufficient to acknowledge meeting of minds. As a result, the court denied the recognized agreement despite 10 years of coordinated price increases. In another case involving life insurance companies exchanging information on future interest rates, the court emphasized meeting of mind standard and denied the existence of agreement. These rulings faced significant criticism in academia and practice. Despite sufficient circumstantial evidence, including prolonged uniform conduct in pricing and even lenience application, the court's insistence on additional evidence for meeting of minds led to accusation of excessively rigid standard of practice proof. So in response, the Korean Fair Trade Act was amended in 2021, explicitly prohibiting acts that substantially restrict competition in a specific trade area through the exchange of information on prices, product volumes, etc. In addition to agreements on pricing, the revised act bans the exchange of information itself related to prices, production volumes, and etc. So this legislative change effectively nullifies the strict evidentiary standard established by Supreme Court precedents. And I will introduce another presumption provisions in Korean cartel law. We have two legal presumption provisions regarding agreements in cartel. The first presumption provision presumes the existence of an agreement when, first, there is uniform conduct in the action of two or more businesses concerning price setting or other behaviors. And second, there is circumstantial evidence, we call it plus factors, supporting a reasonable likelihood of an agreement. Theoretically, this provision shifts the burden of proof for the key facts to the businesses and reduce the KFTC authorities' evidentiary burden. But ironically and interestingly enough, the KFTC has rarely applied this presumption provision. From 2007 to 2018, the provision was invoked in only 4 out of 418 cases in cartel. The primary reason thought to be lies in the complexity of proving the preliminary facts required by the presumption provision. In practice, finding and proving plus factors, the second condition in the presumption provision, became as challenging as gathering circumstantial evidence to directly establish an agreement itself. Consequently, the KFTC often opted to rely on proving implicit agreement itself through circumstantial evidence rather than invoking the presumption provision. The KFTC may find it more straightforward to prove agreement directly using circumstantial evidence, as this approach aligns better with judicial standard. So in 2021, we have another presumption provision. We added information exchange as a form of conduct that could trigger a presumption of an agreement. Under this provision, first, proof of concerted action, and second, proof that the relevant information was exchanged between the parties suffices to legally presume the existence of an agreement. Unlike the earlier provision, this new rule allows the presumption of an agreement with evidence of the uniform conduct and information exchange alone. So it is significantly reducing the evidentiary burden of the KFTC, and we are expecting that this provision will be more frequently and effectively utilized in the future. And I have another issue to want to share with you, but I think the time is more already up. So if there is time before the end of this session, I will mention about that shortly.
Thank you, but and I'm conscious of time, but I wanted to give an opportunity maybe to Marc and Daniel to give us their thoughts on the use of presumption and structural presumptions in the US. There's been a number of proposals to revamp the use of presumption and structural presumption as well, and as Soo-jin said, that may make the life of the task of competition authority easier, but at the same time it may compress due process rights, the rights of the parties, making their life a little bit more difficult. How do you see this debate in the US, and maybe Marc, from your perspective, very briefly, so we can then take some question from the floor. Yeah, Daniel, please.
Thank you. I'll try to be brief. There are a couple proposals by a handful of senators to change the merger laws in ways that would, by and large, make it easier to prove a case under the Clayton Act. And these aren't limited to one side of the political aisle or the other. They seem to actually be coming from sort of bipartisan sources, but there's one introduced several years ago from Senator Klobuchar that would change the requirements under the Clayton Act from a substantially lessen competition to something like a materially lessen competition. And then Senator Lee, on the other side of the aisle, has introduced an act that would codify a merger presumption, I think at 33% post-merger market share. So you see efforts from Democrats and Republicans to clarify, or in some cases to lower the standard of proof. But just to back up a little bit, there already is a presumption in the merger law currently, and this dates back to Philadelphia National Bank, a 1963 case that said when a merger leads to a firm with significant share of the relevant market and significantly increases market concentration, that it's presumed unlawful, absent evidence that the merger didn't have that anti-competitive effect. I just want to conclude by addressing a little bit about sort of ontologically, what is a presumption? A lot of times I think people wrongly say it's a way that flips the burden onto the defendants to disprove. But at least as this particular merger presumption under US law operates, I think it's much more appropriately seen as just a description of a way for plaintiffs to satisfy their initial burden. You actually know a lot about the competitive effects of a merger once you've satisfied the Philadelphia National Bank burden. First of all, you have to prove a relevant market. That's a zone of competition that would harm consumers if it were monopolized. And secondly, because of the market share requirements, it's not just that the post-merger share is large, but that there's a significant increase in concentration. You really know that both parties are substantial competitors in that relevant market. And when it's a horizontal merger, you're eliminating all competition between those two competitors. So you know, at least in the sort of first blush analysis, that there's evidence of a substantial reduction in competition. Of course, there could be countervailing evidence, whether it's economics or more qualitative evidence showing that the presumption evidence was not right, but it doesn't mean that the presumption is simply flipping the burden. No, the presumption is establishing evidence of a likely effect on, or a probable effect on competition. Is there economic support for it? Yes, I think there is economic support for it. Again, this isn't the old sort of structure, conduct, performance paradigm that simply said the higher the level of concentration in an industry, the worse it's likely to function. Of course, in different industries, there are sort of different levels of concentration that might prevail. But the presumption isn't just focused solely on the level of concentration in an industry. It also looks to the change in concentration brought about by the merger. And in a horizontal merger, that change is brought about by the elimination of competition between the merging parties. And I think the evidence shows in a number of studies that when there's a change in the level of concentration that eliminates competition, that's likely to lead to effects like higher prices and other worse outcomes for consumers.
Marc, over to you very quickly, and we can already show maybe the results of this last poll question, which are interesting, but Marc.
Yeah, I think as presumptions, there are many presumptions. I just refer probably to the report, which is the back of the room, which the OECD published in 2024. It's worth reading. You have big categories and structural presumptions and procedural ones. But what I would like to say, you can't conceive a legal system without a presumption. I think of the presumption of innocence. I think we would all agree with that. So the question is, how do we find the right dosage? And that's again the question of the pendulum of history to which I referred at the beginning. That depends on the time. For example, if you go back to the 1960s, where we had a form-based system of notification, immediately you see the court react in a case like Brasserie de Haart, which is a case of the 1960s, with a more effect-based approach to fight those presumptions. Conversely, if there is too much effects-based analysis, you see the legislator react with a more formal approach, like it did in the DMA. So it's an ongoing debate, and probably you will see the same results throughout the ages.
Yes, and if you can pull up the results, I think it's quite interesting and consistent with what we just heard. I think most of you think that, yes, competition system should rely more on presumption, with a big but. 45% of you think, in line with what Daniel was saying, that this should be solidly grounded in economic analysis. So yes to more presumptions, but solidly grounded. So I think consistent with what we heard. I promise to take a few questions. So if there is any question in the room, raise your hand. We'll come around with a microphone. Yes, there's a question here. Please introduce yourself and then ask your question.
Hi, Antonio. I'm Melissa Mariscal from Cornerstone Research. As an economist, I have a bit of a difficult question to pose to the lawyers here. How would you distinguish between presumption and deference? I mean, I know they're different, but the effect of those, from an economist's point of view, sometimes is similar.
Who wants to go first?
I'll give a lawyer's answer. It depends. It depends on the type of presumption you use. For example, the presumption of innocence, to which I just referred, is not a sign of deference towards the prosecutor. So I think it's hard to give an answer in the abstract. I think it depends on, you also have presumptions which work both ways. It's also often related to the burden of proof issue. For example, the issue to which Soo-jin mentioned, collusive behavior. Is an oligopolistic market prone to collusion, yes or no? Is parallel behavior sufficient evidence? You may assume yes, but then you can rebut it, and it becomes a burden of proof issue. So it's hard to give a straightforward answer to that question.
I'm happy to follow up. I think it largely flows from something I was saying already. I don't think it's a matter of deference. Thinking about it in the overall sort of burden shifting framework that most of our antitrust competition law proceeds under, plaintiff comes forward with evidence, defendant can come in with evidence to rebut, offset, or disprove the initial showing. The presumption is just one way of establishing the initial showing. It's establishing a prima facie case, meaning that assuming there just wasn't any evidence on the defendant's side, in the balance, that establishing the presumption is one way of establishing the prima facie case. Of course, in practice, defendants come in with their own evidence, and then the presumption is weighed in the balance. And the case law gives some clarity and structure to what has to be done to overcome the presumption. But I think it's more of an interpretation of the legal standard, the standard of proof, than it really is an articulation of deference to the plaintiff or any other party in the system.
One question over there. So, yeah, Sophia's coming. Oh, no, Angelique.
Thank you. Grégoire Hilland from Brussels. Isn't the issue not more because you can say a lot about, now there are many presumptions about the presumptions, but isn't the biggest issue when the presumption in practice is not rebuttable? And it's more about asking, okay, well, you have the presumption, but if the presumption is a strong indication that it could go one direction, like Daniel said, it's more prima facie position. But if you have a real possibility, then do you have to rebut it with certainty? Or do you have to rebut it with the threshold being there is a reasonable doubt that this presumption is not valid? And for me, that's really the debate. You can put as many presumptions as you want. But if you have only AXO-like presumptions, to speak in European terms, when we see that in 20 years there's never been a possibility to rebut the presumption, is that a presumption, or is that no presumption at all anymore because you cannot rebut it in practice? Isn't that the key question, besides the question of how many presumptions do you want or do you accept?
I know the AXO case very well from a previous professional existence. So I'm subjective on this one. And I would tend to agree in my subjective capacity that it is indeed an almost irrebuttable presumption. And sometimes I would say it would be better and also I would say more honest to say that it is objective liability when it comes to patent liability. And of course, then there are, of course, human rights questions, civil law questions on liability like that. But speaking in my capacity as a former lawyer, I think you're spot on. I think that's the key question. If you introduce in your system presumptions which become irrebuttable, then I think then we are on the wrong way. Then we should say it's an objective liability and it's like that. And it should be in the law, but working with concepts which are basically, cannot be overturned is not something I would be in favor of.
So lots of food for thoughts and for work, maybe at OECD and in other fora. I have to bring this to a close. I don't know if we had a polarized discussion that I can use my last quote from Shakespeare, to be or not to be, prove or not to prove. This is the problem, but I've used the quote anyway. I found a way. So please help me joining the panel for an applause. I think they've done a great job at sort of sketching some of the questions. And one last point. I think our keynotes this morning reminded us how many food-related decisions we make on a day. So this is the time of the day where we make a lot of those decisions. First of all, where to find food. There are coffee areas on this level of the conference center just outside the room. And if you follow the indication towards the auditorium, you'll find another coffee area. But if you fancy a warmer meal, you can take the escalator and join the staff of the UCD in the canteen. Thank you very much. Be back at 2:45 in time for the afternoon session. We have an interesting program, AI and cross-border mergers. Have a good lunch.